name is Steve Sousa. I'm the Executive Vice President of the Massachusetts Board of Real Estate Appraisers, and welcome to this afternoon's webinar, From Complaint to Discipline, What to Know, What to Do, and How to Respond if Faced with a Complaint. A couple of housekeeping matters before I turn this over to Toby. We will be sending out the PowerPoints after the webinar for everybody who's signed up. We're also recording the webinar, and if that goes according to plan, we will be making a link for that available also. And then finally, you should be able to open up a Q&A panel. And if you've got questions while Toby is making his presentation, we would encourage you to ask them using that Q&A panel. The control for that may either be at the top or the bottom of your screen. I'm not 100% sure where it is on this particular service. With that, let me get started with introducing today's presenter. Thomas Toby Bright has a wealth of experience in litigation, including professional liability, employment actions, and matters before professional licensing boards. Prior to joining Hamill, Marson, Dunn, Reardon, and Shea, he served as prosecuting counsel for the Massachusetts Division of Professional Licensure, where he handled a wide variety of matters involving healthcare professionals, engineers, architects, accountants, veterinarians, home inspectors, and speech pathologists. When he's away from the office, Toby enjoys fly fishing, surfing, lacrosse, and home brewing. He's received professional awards and recognitions from rising stars from Massachusetts Super Lawyers, both 2017 and 2018, and he was Northeastern Law Merit Dean Scholarship. He's admitted to the bar in Massachusetts and New Hampshire. And with that, I would like to turn this over to Toby.
Thank you, Steve, and thank you for everyone who's attending. I see we have a pretty good attendance list so far. Just a little bit of an introduction as to how I ended up where I am now. So coming out of law school, I went to work for the governor's office and worked in the boards and commissions office, where we would appoint people to the boards. And from that, I then went over to the DPL to become prosecuting counsel, and I did that for about 3 years. And I don't think it's any secret amongst my former colleagues that I absolutely hated it there, because I don't like taking people's license, and I don't like interrupting people's livelihood. And the DPL is a fine organization. In theory, it's important to be licensing professionals, but they're pretty heavy-handed, and I much prefer defending people and sticking it to the man. So after about 3 years, I was, eager to get out of there, and this firm that I'm with now, Hamill Marson, we do a lot of professional licensing. Worked with some great lawyers over here on opposing side, and they recruited me over there. So for about the last 5 years, I guess it's coming on 6 now, I've been working with licensed professionals, particularly in front of the boards. We do stuff with the Board of Medicine, Dental Board, Nursing Board, psychiatry, you name it, but also obviously professional real estate appraisers. So with that, I'm going to get started, talk a little bit. Basically, the goal here is to kind of sensitize everybody to kind of what's really at risk here. I would tell you that the goal is not to scare you, but it's a little bit to scare you, because if you don't take it seriously right from the beginning, that's where you run into trouble. Once you get down the road into disciplinary territory, it's really hard to get out of that. So Steve, I'm having a little trouble. There we go. All right. So this is an overview of the board. The Board of Real Estate Appraisers, charged with licensing real estate appraisers and enforcing the rules, regulations, and standards of the profession. So it's important to understand that the board falls within the DPL, which the DPL falls into the Office of Consumer Affairs and Business Regulation. And so the reason we point that out is the board is not a industry group. It's not, they're not there to look out for you. They're a consumer protection agency. So their goal is to protect the public from you. They're not there to protect you. And the board's unique. It's a little bit of an overstatement to say that they're unique in that they have federal oversight, but they're uniquely subservient to federal oversight. So obviously, Board of Medicine, medical professionals follow, there are federal laws which govern how they do things. But with most other licensing boards, the federal programs defer to a large degree to the state programs. That's not so with real estate appraisers. The Department of Housing and Urban Development actually come in and do audits of the board, of the appraisal board, to make sure that they're being basically harsh enough when they identify issues. So, and for that reason, the Board of Real Estate Appraisers doesn't respond quite the same way to changes in board staff and board members because they have to be accountable to the federal programs. And so they're a little bit harsher a little more draconian than some of the other boards. Sorry, I have a little trouble controlling this. Just a comment on, board members versus staff. When we're talking about the board, it can become a little schizophrenic because the board has multiple functions. There are board members that actually sit on meetings. There are board staff who can do everything from administrative tasks to actually prosecuting your license. They also have a hearing function. So sometimes when referring to the board, we refer to the board generally. It's kind of really referring to DPL. Sometimes you're specifically referring to the board members themselves, and other times it's the staff. So board members, there's in the current iteration of the board, or I guess the former iteration of the board, there's 7 board members. And what I'm referring to there is Steve and I actually were just discussing this. There's been new legislation for appraisal management companies, and in that legislation, they've actually disbanded the old board and created a new one. So it's a little bit blurry where exactly that's going to go. But board members, generally speaking, are appointed by the governor. They meet monthly, they make decisions. They're not compensated. If you do get a complaint, if you do have a case, they don't know your case. They may have sat in on a meeting where it was discussed for 10 to 15 minutes. And so they're not really the ones that are driving the ship most of the time. They make important decisions, and the board staff have to defer to them, but they're only there occasionally. Board staff, on the other hand, they're the full-time paid employees. They handle the administrative functions. They have very limited discretion in making decisions that ultimately are going to affect your license, but they do have a great deal of influence on the process where a complaint may go. And in some instances, they're pretty close to the board members and have a great deal of influence over them. So important to keep the board staff happy and on your side and be polite to them. But you still got to recognize that, just because you think a prosecutor or an investigator is sympathetic to your plight or sympathetic to your, what you think should happen, doesn't mean that that's what the board's going to do. So investigations is part of the consumer protection mission. The board is duty bound to investigate complaints against you. You may think, well, this complaint is completely meritless. It's crazy, makes no sense. The board, if they get a complaint, it's in their jurisdiction, and anything basically having to do with you or your conduct as an appraiser is going to be in their jurisdiction. They have to investigate it. So this is a little bit of our lame attempt at humor, but what do you call them? Alligator and a vest investigator. So board opens investigation when anyone, whether it be a consumer, a competitor, a colleague, or a stranger, files a complaint against you. They can also initiate their own investigation. So if someone files a complaint against someone else in your office and the board during their investigation finds something in the file that suggests that there might be some reason to open a complaint against you, they can do that. You know, this is really kind of a hard pill sometimes to swallow. You know, so just as an example, have a current case pending where an AMC was putting a lot of pressure on the appraiser to change value assignments. There were some disputes about billing, and you know, the appraiser pushed back, said, "No, I'm not going. You can't. You know, this is my opinion. I'm not going to change the value, and also you need to pay me for the appraisals that have been done." The AMC turns around and files a complaint. Now, you might say, well, you know, that's clearly retaliation. That's, you know, impure motives, doesn't matter. Board gets a complaint, they're going to investigate it. Grounds for discipline. Some are obvious, others less so. Obviously, if you do a bad appraisal, you know, that's completely unsupported, you make errors, that is a ground for discipline. But others less so. So not cooperating with any request by the board to appear, given information, that's an independent grounds for discipline. This becomes really important later on. If you get a complaint and you don't give them everything they ask for, or if your response is incomplete, that can be a basis for discipline. You know, when they ask for your work file, and we'll talk about it a little bit more, you got to give them everything in your work file, because otherwise they're going to assume it doesn't exist. And then if you produce it later, they're going to say, well, you didn't produce it when we asked for it, so that's a basis for discipline. If you get disciplined in another jurisdiction, that's a basis for discipline, even if it had nothing to do with what you're doing in Massachusetts. Criminal matters, that'll get you a basis for discipline. You get an OUI, that can be a basis for discipline. There's this blanket provision of unprofessional conduct, whatever that means, that's a basis for discipline. And so something that you may not even, as of right now, it may not even be a rule. If they determine that that's unprofessional conduct, that can be a basis for discipline. So the takeaway is, just because you get a complaint that doesn't seem like you've done anything wrong, certainly not from, you know, your appraisal was A-okay, you know, completely, nobody can argue with it, doesn't mean that they can't discipline you for something else. Where do they come from? Mortgage holders. So this was especially true back when I was at the DBL in around 2011. There was still a lot of fallout from the financial crisis. Mortgages were going bad, and one particular bank, I think it was Citibank, was filing complaints against all the appraisers and all their bad mortgages, saying that, oh, well, you know, had you appraised it better, they wouldn't have written the mortgage and the loan wouldn't have gone bad. So obviously, you know, that was pretty disruptive for a lot of people. Real estate brokers, both sides, sellers and buyers, you kill their deal because you didn't give enough valuation to support the sale. Mad about that. Buyers and sellers, as you probably know, you know, a lot of people can take house valuation pretty personally. Like if they think their house is worth, you know, $800,000 and you appraise it at 700, they're going to be angry about that. Sometimes it doesn't even make sense. We actually have a current case with someone who was buying the house and it was appraised at less than they were going to spend on it. And they were really mad about that. They apparently wanted to spend more, but you know, it doesn't really matter what their motivations are or whether or not it makes a lot of sense. Appraisal management companies, obviously they've gotten bigger in the last few years. They can file complaints, and they do. Attorneys are just terrible people. And then the board itself, like I said, anything they learn about you can trigger a complaint. CEU audits, news reports, you know, that kind of goes into the OUI type of thing. If you do something not even necessarily related to the practice of, you know, appraising, they can still open complaints against you, and they will do that. You may actually, I think it was when I was still at the DPL, so back in like 2011, when those Russian spies were found in Cambridge. One of them was a licensed real estate broker. And believe it or not, they opened a complaint because she was a spy. So anything can cause that, or can trigger a complaint. So you receive a complaint. They're looking for a narrative response from you, kind of tell us what happened. And then they're also going to ask for a copy of your work file. So you have an obligation at this point to respond. And anything you don't produce is going to be presumed not to exist. And this, again, is really important, because what's going to happen is the investigator is going to take your response, you're going to take your work file, they're going to have somebody review it, and they're going to then present it to the board to determine whether or not there's any problems. If you are missing some sort of supporting documentation that you should have, the board's going to assume that you don't have it, and they're going to ding you on that. And then when you come back later and say, oh no, I do have it, they're going to say, well, you didn't produce it when you're supposed to. So if you do get a complaint, a couple of things. Take it seriously, don't ignore it. It's a huge mistake. And the fact that you're probably here suggests that you take this seriously. Doesn't necessarily mean that everybody does. So people do ignore these things. Contact your E&O insurer first and foremost. If you don't do this at the complaint stage, it could result in a denial of coverage. I hear sometimes, well, I don't want my premiums to go up. I don't really think this is going anywhere. Look, this is why you pay for E&O insurance. It's for these types of situations. If you do end up having a complaint that goes forward to a hearing, it's going to cost upwards of $10,000 to $20,000, probably even more actually. If you go all the way through, if you end up needing to appeal it, you're going to be into the $40,000 range. So contact your E&O insurer. Whatever increase in premiums, if there even is one, it's worth it. Seek the assistance of counsel. Don't do it alone. And seek the assistance of counsel as early as possible. Don't wait until it's escalated, because once it's escalated, it's really hard to de-escalate. Again, take it seriously, even if you think the complaint is frivolous. So again, whatever the motivations are of the person complaining against you, even if they're crazy, even if what they're saying is completely nonsense, that doesn't mean that the board investigator isn't going to find something that is serious. And once your work file gets reviewed, the reviewing appraiser can rip apart pretty much any appraisal. You're going to say, well, this wasn't adequately supported. It's a certain degree of subjective standard there, or, I would have done it this way or I've done that way. It gets, just the fact that they're looking at a specific appraisal can cause you problems.
Toby, just as an observation, I've heard often that it's a good thing to talk with an attorney early, simply because the first communication back to the board sets the record, and you want to make sure that your communications are all appropriate and phrased the right way, and presenting whatever it is that you're responding to in the best way. Is that an accurate comment?
Thank you for bringing that up. That's a great point. So, you want to be professional in all your interactions. You don't want to be angry, and because a lot of times you get that complaint and you're angry and you fire something off and you say, how dare you suggest X, Y, or Z. That's not a good way to come across to the board. The board's going to look at all, or has the potential to look at all your communication. And so it's really important to speak in the right tone, to present all your information in the right tone. You don't want to say something that you regret later. And speaking with an attorney, speaking with your E&O insurer, you can get guidance on the best way to proceed. So you get a complaint, don't ignore it. Don't assume the board investigator is on your side. Again, the board investigator has a fair degree of influence over the process, but even if you're best friends with the investigator, the board can still find fault with whatever you've done, and they're the ones who get to make that decision. Again, don't assume it's no big deal. take it seriously. Make sure you're producing your work file. Make sure you're giving a thorough response. You want to put, the best gloss on whatever happened. And don't communicate with anyone else at the board. If you're gonna, as you should, seek the assistance of counsel and your insurer, don't call up the board and say, "Oh, hey, F this. I'm so angry, blah blah blah," and then call your board counsel, then call an attorney, and at that point, there's already been a record of you basically flying out the handle. And also, they'll seek to interview you. Basically, they'll seek to get a statement out of you before you've had time to collect all your thoughts. So again, don't underestimate the severity of the situation. Your best chance at a good result is early. It's really, really, really hard once the process is going to dial it back. Just as an example, we recently got a case dismissed. It was a great result. Case never should have gotten there, but it was 7 years after it started. So, had that been handled appropriately right from the beginning, I don't think it would have made it that far. But, that's the risk. Even if you get vindicated at the very end of the process, you need to do that in the beginning. And again, your appraisal is going to be closely scrutinized. So just because, let's say the complainant, accuses you of, stealing something while you're doing the appraisal, and it's complete nonsense, that part may never go anywhere, but your complaint's going to be, or your appraisal is going to be looked at very closely. We had a recent case where the complainant accused the appraisal of misleading him about how many bedrooms his house had. He actually had the house built, so he knew exactly how many bedrooms the house had. He was using it as a 3-bedroom. He's somehow managed to get it permitted as a 1, and of course is blaming the appraiser for not realizing that he wasn't actually supposed to be using his house the way he was. So that's nonsense. But the appraisal is going to be looked at very closely. So you need to be on high alert as soon as you get a complaint. We always tell clients, if you get anything from the DPL that's not a license renewal form, you need to contact a lawyer. So after the investigator feels that they've conducted a thorough investigation, they'll present their findings to the board. They can do it at a full board meeting or in front of the complaint committee, which is a sub committee of the board. You might be invited to attend the meeting, which they'll call an investigative conference. Again, the earlier you get involved, the earlier you handle it, the better. If the board's, if you can get into the front of the complaint committee and make a good presentation and explain to them what happened or why there's nothing wrong, and you convince them and it gets dismissed, that's great. If you don't make a good presentation, or you're not able to convince them that it's time to get dismissed or that the complaint should get dismissed, you'll end up in prosecutions, which again is really, really hard to get a complaint dismissed at that point. So again, if after that preliminary investigation and the board of the complaint committee determines that it's frivolous, they'll dismiss the complaint without prejudice. Without prejudice means that they can always bring it back. You don't get stuff dismissed with prejudice, so that's not necessarily anything you're going to have control over. But just be aware that just because it's dismissed doesn't mean that that's the end of the inquiry. And again, don't assume that you're going to get to dismissal just because you think the complaint is frivolous. If you have a CEU problem, you lost your work file or something like that, those are pretty guaranteed ways to end up in prosecutions even when you've been doing it wrong. But if after the complaint committee, after that investigative conference, they decide they need more information, they can always send it back to the investigator for more information, and they'll keep investigating, trying to find out if there's anything to the complaint. All right, so worst case scenario, board determines discipline is warranted. Case gets forwarded to prosecutions. That's what I used to be, prosecutor. Prosecutor is given what's called the yellow sheet. And on the yellow sheet, it says what the prosecutor can settle the case for and what allegations they have to prove or you have to admit to. And so they'll have settlement terms that they'll offer you. The board loves probation. And part of probation with pretty much every consent agreement is you need to take USPAP courses and you need to take another test. So, and that's pretty standard. If they send it to prosecutions, there's going to be some term of probation and usually also a fine, and then you'll need to take courses. So that order to show cause, or so what they do is they issue an order to show cause. Your counsel will reach out to the prosecutor, find out what the board's proposing. You'll have a chance to settle it then. If you don't want to take what they've offered, you then go to a hearing. So this is the order to show cause, or a example of an order to show cause. It's pretty lengthy, so I pulled out some excerpts. As you see on the bottom here, or on the right panel, it says order to show cause. It says, you are hereby ordered to appear and show cause why the Massachusetts Board of Registration of Real Estate Appraisers should not suspend, revoke, or otherwise take action against your license. So they all say that. They're proposed right at the beginning. They're giving themselves the option of completely revoking their license. Now, on the left side, this is paragraph 7. This particular order to show cause had 3 properties. This is just talking about one of the properties. And as you can see, it's got that long list of deficiencies that they allege in the appraisal. They don't give a ton of specificity, but as you can see, you failed to provide an adequate legal description for property 2. You misidentified property 2 as owner occupied. You included an inadequate analysis of agreement sale for property 2. You included inaccurate or inadequate zoning description for property 2. So they go through a list, all these different things that you allegedly did wrong. You might read this and say, wow, this was a bad appraisal. No, it actually wasn't. As far as we're concerned, all these allegations are meritless. They don't tell you really what the actual criticism is, but like I said, they'll rip apart every appraisal that they get. It's very rare, as far as I know, that their reviewing appraisers say, oh yeah, no, this was a good appraisal. So based on all those horrible things, they start listing out all the reasons why you need to lose your license. So as you can see, there's 15 different bases for them to revoke the license here. One of the things, paragraph 11, right up there in the top right corner, violates USPAP record-keeping rule adopted by the board for preparing a work file that fails to include true copies of any written reports. So what happened here is when the appraiser put together the work file, this is before counsel got involved. When they putting together the work file, they only included the final copy of the appraisal. There was some back and forth between the AMC and the appraiser, and there were actually 5 versions. This allegation strictly revolves around the fact that they only provided the final one and didn't provide the other 4. So it puts you, if you don't provide the best response possible, you're putting yourself in a position where now it's kind of a catch-22, because we say, wait a minute, we have these other 4 reports. They're going to say, well, you already violated the rules by not producing it in the first place. So it's really important, like I said, and I can't really say it enough, to get counsel involved early, to be thorough, and to take it seriously when you're responding in the first place. So again, the consequences of this can't really be overstated. You risk losing your license. They post this on the DPL's website sometimes as press releases, but it's also available on your online profile. The other thing is, even if you don't lose your license, I said earlier that the board loves probation. Probation isn't an entirely innocuous status. So if you're on probation, even though technically you're not impacted in your ability to practice, probation doesn't usually come with monitoring obligations. It's really just, you're kind of just in this probationary status. It can affect your clients and who's sending you assignments, because some AMCs, some clients won't work with people on probation. I recently was speaking to a client who'd gotten through the probationary period, and I said, how did it impact your business? And he said, if I didn't have one category of appraisers, I would not have made it. So that's something to think long and hard about, is, even if you don't risk losing your license, or even if you don't lose your license, not taking this seriously can still have a huge disruption on your business. So, voting discipline. The easiest way is to be mindful of all ethical obligations, stay current on your CEUs, and carefully document your work file. So your work file must be kept for 5 years. And I just want to go over what's in a work file. There's the USPAP record keeping rule, which lays it out in a little more detail, but going back to the situation I described earlier, where only one version of the report was produced. The board's regulation on record retention includes all reports and supporting data. There's no limitation on that. So you need to produce everything. So if you are saving electronic versions of the appraisals, if you have drafts, print those. When the time comes, you need to print them out. And you also need to back them up and save them, because if you lose them in the intervening 5 years, that's a violation. I also like to just talk briefly. So we did this webinar 2 years ago. And at the time, we got a question, which was, do you recommend destroying your work file after 5 years? And at the time, my advice was, I'm not really sure. Sometimes there's something in there that might be helpful to you if you get a complaint or some sort of litigation sometime down the road. I've changed my advice. Absolutely destroy your work file after 5 years. There's an exception, by the way, if you get notified that there's litigation pending or there might be litigation concerning that appraisal, then you need to hang on to it. Otherwise, get rid of it, because the board has a regulation that states that if you are no longer required to keep your work file, that it essentially serves as a statute of limitations. There's exceptions to that, so if there's ethical reasons to discipline you, then they can still go forward. But if it's strictly about your appraisal and it's been more than 5 years and you don't have your work file, they can't, or they have a regulation that says they won't go after you. So when that 5 years comes, get rid of it, because that's a good way to insulate yourself from a complaint over that property. Now, if you still have it and the board asks for it, you have to turn it over. One thing that's always important, honesty is obviously the best policy. Cover up is way worse than the crime. So I never tell the board an untruth. Part of hiring a lawyer is finding out the best way to say the truth in a way that's not going to get you in trouble. But so that's just my spiel on work files. So continuing ed, I'm not going to go deep into the details, but like I said, one of the things that kind of can trip people up is record keeping and CEUs. If you don't do your CEUs, you can't retroactively do them and then not get in trouble if you get audited or they request them. Again, I would definitely not suggest trying to fudge any CEUs. So do them now. It's just a basic risk management. It's your obligation to do them. So obviously one of the most common complaints received by the board is an appraiser did not value a property correctly. I'm not here to teach you USPAP, but obviously that's something you need to be mindful of. So ethical concerns, like I said, the statute of limitations I was referring to, which is technically not a statute of limitations, but I'm gonna call it that, doesn't apply to ethical violations. So obviously really important to be aware of those and to follow those. So your primary obligation is to your client to reach complete, accurate, and credible conclusions and numerical results, regardless of the client's wishes or instructions. AMC is obviously intended to kind of to provide some insulation between there. So far, I don't see that that's actually solved anything. In fact, it seems to have made it worse in some instances. Keep all matters relating to the appraisal assignment confidential. Again, fairly well, I think it's straightforward stuff. Obligation to competent services. Don't accept assignments that you are not qualified to appraise. Imply that you have professional qualifications that you don't have. Do make sure you're aware of make sure clients are aware of delays or reasons an appraisal is not or cannot be completed, and make appropriate arrangements to assist in the transition to another appraiser. One thing in this vein is to be really mindful of your electronic signature. The board has a pretty zero tolerance, strict liability policy on electronic signatures. So if a report gets generated with your electronic signature, and even if you knew nothing about it, the board will come after you for failing to control your electronic signature. So that can cause some kind of tricky situations, especially where you are in an office and you are relying on assistants to do that. If you're communicating your report to a home office or to the assigning appraiser, you need to make sure that the staff aren't going to be making changes without your knowledge and without you putting your signature on it yourself. Also, on the same vein, if you are in that kind of situation where maybe you're working for another appraiser or they're sending you work, you need to make sure that you understand what the assignment is coming in. Had a case where the assignment came in with a no reassignment clause. That wasn't communicated to our client. And so she did the appraisal and submitted it, thought everything was fine. Later on, she gets brought in front of the board on the accusation that she misrepresented who was doing the appraisal. When you're giving testimony, you got to be objective and without bias. You may rebut another appraiser, but again, you got to be objective and honest. And you can only comment on the work product, the appraisal itself. So it's an ad hominem fallacy. Face is an ad hominem. So no ad hominem attacks. So you can't say, well, that appraiser is known to be a terrible appraiser. By the way, he got disciplined by the board. Can't do that. So again, when you're giving testimony, it's the same obligation. Basically, as regarding your work file, is when you're doing an appraisal yourself, you need to document that. So again, if you're doing an appraiser with more than one client, you can't do that except with consent. And you want, good practice. Part of good record keeping generally is you want to have them sign a waiver as far as conflict. So in summary, be mindful of all your compliance obligations. That includes maintaining your work file, doing your CEUs, carefully document and adhere to all USPAP standards. It's better to have a thick work file that covers everything than to leave something out. If you receive a complaint, which hopefully you won't, contact your insurer first, seek the assistance of counsel, and don't underestimate it. I've had 2 clients in the last month, or 2 months maybe, who didn't take it seriously at first. They're now in prosecutions and their insurer is not covering it because they didn't tell them in the first place. That's a completely avoidable situation. It's really unfortunate because it's going to be expensive. And if you're in that situation, you end up kind of with this tough choice of a cost-benefit analysis. Not only is once you're in prosecution, it's hard to get a better result, and you don't know if you're going to get a better result than what they're offering you in the first place. And you don't have the money, you don't have the support of your insurer to fight it. So you're left with this decision to, do I spend $10, $20, $30,000 trying to get a better result that might not happen, or do I accept it now, get my probation over with, and the possible risk of loss of business. So again, really unfortunate and completely avoidable. So that's the slideshow. Steve, I don't know if you have anything to add.
We haven't had any questions come in yet, but what I would ask is, those of you who are on the call, if you would like to send me an email if you have any questions, that would be great. I can forward them on to Toby, and I know he would answer them in writing so that we could get the answers back out to you. The other thing, Toby, that I'm just interested in is, and just wanted to clarify for a second, is if you actually give control back to me, okay, then when a complaint comes in, how soon after the complaint comes in do the board members get to see the complaint? Is it right away, or is there a delay until, say, for example, the investigation is done?
Yeah, so the board doesn't see the complaint until the investigation is done. So the complaint comes in, and then it gets processed by administrative staff. That can take anywhere between, a few weeks and a few months. They don't move all that quickly. The letter goes out to the licensee, says, we want your work file, we want a response. Send in the response, and it could be, again, a few months before they finish their investigation, at which point then it's finally presented to the board, and that's when you find out. From initial complaint to final resolution can be as quick as 6 months to a year is a pretty quick resolution. Like I said, we've had a client that it took 7 years. So it's not a fast process, even when you get that letter, and even if it's going to be dismissed.
Okay, I think we have somebody who I think wants to ask a question, and I'm trying to make sure who it is. John, I'm gonna kind of unmute you, and if you'd like to ask your question, go ahead. John? Okay. I may not have figured out how to unmute him. So sorry about that. So John, I guess if you have a question, if you want to email it in to me, I'll be glad to get it on over to Toby. I think, we've done a good job here of overviewing the process and what appraisers should expect if they do receive a letter of complaint. I think it goes without saying that the most important steps are to take it seriously, to contact your E&O insurer. And I know, for example, with Landy, they actually have an attorney hotline. which doesn't open a complaint, but you can at least get some initial feedback from an attorney through Landy. And then, you know, money spent on an attorney to represent you is not something that you should hesitate to do, because this is your livelihood and you've invested a lot to become an appraiser, and you want to make sure you do the best job you can in making sure that you can maintain your license and your livelihood. So with that, I'd like to express my appreciation to Toby Bright. As I mentioned at the beginning, we'll be sending the PowerPoint slides out to you in a little bit. And if you have any questions, again, please send them on to me and I'll get them to Toby for a response as quickly as we can. With that, I'd like to just say thank you, and we're now going to end the webinar. Thank you.